The following program is a presentation of NET Connects.
Many Nebraskans are being confronted with the challenges of protecting themselves and their loved ones from the threat of elder abuse, neglect, and exploitation. One Nebraskan, whose mother was a victim of family violence and elder abuse, told us, elder abuse is not always just something you can see, like physical abuse, or that you can find, like financial abuse. It can be mental abuse. I miss the signs of elder abuse, and I don't want anyone else to miss them. I just don't want anyone else to go through what we did. A simple call to the hotline may save a loved one's life. To provide protection for vulnerable older adults and to help older Americans with legal assistance on issues, the Older Americans Act was established. It decrees that older Americans are entitled to certain basic rights and benefits, such as income security, health care, consumer protection, defensive guardianship and housing, and provides legal assistance on these priority issues. Legal assistance is one of the priority services of the Older Americans Act. In Nebraska, legal advice and representation is provided to those 60 and older with economic or social needs through our 8 area agencies on aging. The area agencies on aging contract with private attorneys for these services or with Legal Aid of Nebraska to operate a hotline to provide legal assistance. The area agencies on aging based in Lincoln, Norfolk, Kearney, and Hastings contract with a private attorney in addition to the Elder Access Line that is available statewide. These legal providers help older Nebraskans with advance directives such as wills, durable and health care powers of attorney, as well as other things like eviction notices, debt collection, and government benefits. The State Unit of Aging within DHHS also sponsors free law school clinics throughout the state that prepare advance directives and provide consumer credit counseling. In today's program, legal experts will discuss some of the legal issues and point you to resources in your community to find help. It's time to talk money. With us now is Margaret Schaefer of Legal Aid of Nebraska. And let's start off by telling folks a little bit about Legal Aid and about the Elder Access Line.
Legal Aid of Nebraska is the law firm in the state of Nebraska that serves people that are generally low income. But through the Elder Access Line, we also can help people that are over the age of 60, or actually 60 plus, with their legal issues and questions, regardless of their income and assets.
Let's start off by talking a little bit about debt. That's the big problem that you deal with, right?
I sure do. There's a lot of seniors in Nebraska that are struggling with debt. A lot of times something's happened unforeseen. A spouse has passed on, or perhaps they've lost a job or become ill, maybe had some other tragedy in their life, and they find they can't make ends meet. And so trying to figure out how to use their scarce resources to take care of necessities becomes a burden and a challenge.
I think when a lot of people hear the Elder Access Line or Legal Aid of Nebraska, they think that it's just to deal with legal issues specifically, but you offer a lot of advice.
We offer a lot of advice. We can help folks that are dealing with these kinds of issues at all stages. So I might have someone calling me who is current on all of her bills, but is really having a hard time prioritizing. So we can give some good advice about what the consequences might be of paying or not paying each one of their items as they come in. And then if they are unable to pay everything, then they may face lawsuits, they may face other legal actions, and we can help them through those too.
If you're sued for a debt, let's talk a little bit about that process.
Yeah. If you're sued for a debt, we do an analysis to see what the risk might be to you. There are some provisions in the law that protect folks even though they owe a debt. And those provisions are pretty straightforward and pretty obvious for the most part. If you have been sued, your first step is to file an answer. An answer is to dispute that you owe it. Sometimes that doesn't make any sense for folks because they know they owe the debt. That's not the question. The question then becomes what income and assets would be at risk from a creditor. It's very important for clients to understand that Social Security is a protected or exempt form of income. So if someone's receiving Social Security, it's available for their necessities, for those things that they need to buy now. It's not available to be garnished by a creditor in the way that wages might be for someone who's employed. There are other protections under the law for assets, and so we'll review what do you own, what might be at risk now that you've got a lawsuit against you, and what is protected. And a lot of times folks are much relieved to find out that what they have is protected already and that they don't have as much risk as they thought.
There are income guidelines that we deal with all of these things. Are there some of those that are easy to address in the time we have?
Well, income guidelines for the collection issues, it's more income type than amount. Like I mentioned, the Social Security, there's also other federally protected benefits. And so it's what kind of income you have that determines whether it's protected or not.
What about collections calls? Let's talk about those.
Oh boy. The Fair Debt Collection Practices Act does allow for some protections for folks if they're getting a lot of calls. What you need to do is send a letter to the collection company and let them know that you do not wish to receive phone calls anymore. We call it a do not contact letter. We have samples of those on our website, and that website will be listed on the screen and at the end of this segment. But the do not contact letter is just a very simple mechanism that people can do themselves to help bring a little peace of mind.
Let's talk more about bankruptcy. That's something that a lot of people deal with, but especially some older Nebraskans.
Sometimes elders want to do a bankruptcy, and there might be a reason to do that. If you have unprotected income, such as wages, you may need to do a bankruptcy. A lot of times folks don't need to do a bankruptcy, but you don't know that unless you've walked through it with our paralegals on our Elder Access line. A bankruptcy, there's two kinds. One would have you making payments, and that would be a Chapter 13, and that might be necessary if there is some secured debt or unexempt assets or things like that. A Chapter 7 is more common, and it's a simple bankruptcy generally, and that's for folks who really don't have any property they're trying to protect. There are income requirements for those kinds of bankruptcies, and they're very, very complicated legal matters, so we recommend a phone call just to talk it through.
Let's talk more about scams and fraud. Do you get a lot of questions regarding?
I do. I get a lot of questions about scams. Sometimes people will call me because they think they've won something and then they find out that they didn't. What I want people to be looking out for to protect themselves on scams and frauds are those things that don't sound right. If you have not entered a contest but you're winning a contest, that's not good. If somebody wants you to pay money to claim a prize, that's not so good either. Those are red flags we're looking for. The other things I want people to be thinking about are, is it something you have to do right now? That hard sell, the don't wait, that's not something you want to participate in. If you have someone coming door to door, especially with that hard sell, then you want to be really careful about signing up for a service or buying a product or having repairs done. If you didn't know you needed that service before they knocked on your door, you need to think really carefully about signing up for it after they knock on your door.
When we talk about financial issues, I suspect that a lot of older Nebraskans will say, when I look back on it, there's one thing I wish I knew or wish I would have done differently. Can you share one of those or the most common?
The most common is getting information. If people know what their rights are, then they're not going to be taken advantage of. If people know what to look for, they generally can avoid those scams and frauds. Go with your gut, but find out, get educated, and get information about your situation.
Well, we are a rural state, a very large state, and most of it is rural.
Yes.
So one of the great things about what you do is that it's available via telephone from anywhere in the state of Nebraska.
That's right. You can call us from anywhere. We're happy to talk over a variety of issues, not just consumer things, but many other kinds of situations. We talk about family law matters, public benefits, lots and lots of different things. Housing, I get calls for that, for other legal documents. We can help with a variety of things, and we're just a phone call away. We're open limited hours. That's because of the nature of staffing, but we're open 9 to noon and 1 to 3 Monday through Thursday, and 9 to noon on Fridays. And again, that phone number will be listed on your screen at the end of the session.
It's important work that you do, so thank you for making it available to folks all across the state.
I love working on the Elder Access Line, and I love talking to Nebraska seniors every day.
All right. Well, the phone number for the Elder Access Line and more information about Legal Aid of Nebraska showing on your screen now. Mary Wilson of the Buford Law Office is here to talk about the legal aspects of older Nebraskans. Let's start off with powers of attorney and living wills, what the differences are.
They're all documents that let you ahead of time decide how things are going to be handled if you later become incapacitated. The financial power of attorney, which is sometimes called a general power of attorney, allows someone to help you with your finances. The healthcare power of attorney obviously allows someone to make medical decisions for you when you're incapacitated. The living will somewhat stands alone and speaks for you, and it directs your medical staff on how you want the end of your life to proceed, what kind of interventions are acceptable to you and which are not.
And at what point should people have them?
They should be made out when you're very young. We actually establish more guardianships for young people that are in accidents than for older people. So it's something you should take care of fairly early in your life. But for certain, by the time you reach an age where natural processes might start impeding your ability to either handle things physically or mentally.
Let's talk about disabilities as it relates to financial powers of attorney.
Well, the good thing about financial powers of attorney is that they're not transferring any powers away from you. But they can be set up so that they could be used just because you're physically incapacitated, or they could certainly be used if you're mentally incapacitated. And you get to decide when that power is transferred. Does it get transferred the minute you sign the document, or does it get transferred when you actually are incapacitated?
What happens if you become mentally impaired and have not executed powers of attorney?
Well, then unfortunately your family or friends will have to seek guardianship, perhaps conservatorship through the court system. And they will be highly irritated with you if that happens, because it's much more expensive and it's much more complicated. Now, sometimes that is the best alternative, without a doubt. You may not have someone trustworthy to give power of attorney to, because no one's going to be monitoring what that person is doing, or there's going to be very little monitoring of it. But that is what will happen if you don't get it taken care of, is eventually a guardian or conservator might have to be appointed through the court.
Let's talk more about the healthcare power of attorney in some detail, some specifics about what exactly it provides for.
It, first of all, becomes effective only when a doctor says you're no longer able to make your own decisions. And your agent is instructed to try to communicate with you, even if it's just a matter of speech impairment or something else that might affect your being able to communicate easily. But it allows another person to make medical decisions for you. They can decide what kind of surgery you're going to have, or where you're going to be placed for health care, whether that's in a hospital or a nursing home or treatment facility. Now, if you want that person to also make end-of-life decisions, like whether or not to use artificially administered nutrition and hydration, or whether or not to use life-sustaining treatment like CPR. Those decisions can be given over to that agent, or your living will can step in at that place and make those decisions for you.
Let's talk about those agents. Is it one person or can there be more than one?
There can be more than one person. Now, going back to the financial power of attorney, you could have multiple people serving all at the same time. You could set it up so they could act independently of each other, or that they'd have to all act together. With a healthcare power of attorney, you can only choose one person at a time. But the law says if that first person is just reasonably unavailable, you can go ahead and go to the next agent.
Let's talk more about living wills.
Many times mistaken for trusts, living trusts, which is a totally different thing. A living will is a written way to express how you want end-of-life decisions handled. Do you want intervention medically if you have a terminal illness and death is imminent in a short time? Would you want to be fed through tubes in your nose or your stomach? If you were in an accident and something happened so that you were in a persistent vegetative state but not necessarily terminally ill, would you want medical intervention, or would you want the process to just occur naturally?
We talked about agents with the powers of attorney. Are there agents for the living will as well?
No, that document speaks for itself. It's just a written communication that you give to your medical providers. It is important to realize, though, that if you make out a living will, the doctor decides when the condition has been met. Are you now terminally ill? Are you now in a persistent vegetative state? And although the medical community, the provider, usually a doctor, is obligated to notify your family that they think the time is here, that they're going to, for example, take off a machine, the family doesn't have the right to intervene and stop it.
A living will is not a replacement or a substitute for a healthcare power of attorney, though.
That is correct. So frequently, clients will come to the office and have me look at their living will, and I'll say, well, do you also have a healthcare power of attorney? And they'll say, well, no, this is what I want. And that is true. But so many times, the medical decision doesn't involve terminal illness or persistent vegetative state. It might involve Alzheimer's, Parkinson's, some type of a long-term chronic debilitating illness.
Let's go back to the financial power of attorney part. What if people are married? Do they still need one since their spouse would normally make decisions?
Absolutely, and I think that's another very common misconception, and that is, well, we're married, both of our names are on everything, so why do we need power of attorney? Well, have you ever tried to get something out of your spouse's IRA? That's not joint. And so much of wealth now is in those type of retirement accounts, or perhaps a check will come that needs to be endorsed and deposited, or maybe your Medicare will get messed up, or maybe you'll need to sell the house and buy something more conducive to your current situation. All those things require power of attorney. Being married and being joint on most everything doesn't solve those problems.
And I suspect people think kind of the same thing about their kids, that their kids can easily access things for them as well.
Right. So often a parent will say, well, my daughter's on my bank account, and assume that handles everything. And of course, those same kinds of issues can come up. You may need to apply for Medicaid. You may need to straighten out some kind of a Medicare problem. All kinds of things that being on the bank account is not going to solve.
What's the most important thing people need to know about these legal issues?
Preserving autonomy is so important, and you need to consider the fact that to be fully autonomous, you need to make the choice also about who's going to step in if you become incapacitated, so that it's not just up to the court to appoint one of your 7 children, and they may not make the decision you would have made. It's important for you to take control of all aspects, even the possibility that you might not be able to handle things till the day you die.
Mary, thank you.
You're most welcome.
And information and resources are available at the numbers on the screen, your local area agency on aging. With us are Douglas County Court Judge Susan Bezos and Deborah Denny of the Nebraska Supreme Court. And we know that there was some important new legislation that was passed a few months ago regarding public guardianship. Can you tell us more about the new law?
Yes, the legislature passed the Public Guardianship Act this last session. We are the last state to have this type of legislation. The purpose of the legislation is as a last resort. If someone does not have a guardian or conservator, then the court can appoint a public guardian to serve in that capacity. The law will not become effective until January 1st of 2015. But we won't be able to take cases, or the public guardian won't be able to take cases till probably the spring of 2015 due to regulations and rules that have to be developed and in place prior to them taking on any cases. Probably the biggest thing that the public needs to know is that the court has to refer someone to the public guardian in order for the public guardian to be appointed. Someone can't just be able to call them up and say, I need a guardian, here you go. A court will have to refer or appoint the public guardian to serve in that capacity.
And so where does someone start?
They will start at their local courthouse where the ward resides, generally is where the paperwork is filed, and that's the starting point, is to file a petition indicating that they need a guardian or conservator.
We know that if you're a guardian or a conservator, that you have to file annual reports to the court. So tell us more about what the Supreme Court has done to make that an easier, a simpler process.
The Supreme Court really looked at that issue because they had gotten some feedback. The courts now look at all documents that are being filed annually, which is a new process and something new for the courts. And within that process, if someone doesn't file what needs to be filed, they're notified that you're missing something. And so most of the people that are filing these reports don't have attorneys anymore. They're what we call pro se. They're doing it on their own. So we created a packet, and within that packet there are detailed instructions of what they need to do. The idea is that if they complete that packet in full, fill out the whole entire packet and send in what the instructions say they need to send in, then they will have filed everything with the court and they won't get notice from the court that they missed something. In addition, we do send out 45 days before that packet is due, we send out a notice saying your reports are due in 45 days. And that is something new. In addition to that, a lot of the counties that are sending out those notices send out the packet with that information, or with that information sheet that your reports are due. The other thing is, and probably what's most important with those packets, is that information also is sent out to interested persons, or what we call interested parties. And those are the individuals such as family members or someone that maybe the court has approved to be an interested party, a close friend. Gets that information because the courts feel that they're in the best position to look at that information and let us know if someone didn't report something correctly or maybe something was left out. Because the court doesn't know or know the people personally, obviously, and so those that are around them the most probably have the best information or the best insight to let the court know if there's a problem or a concern.
Deborah, tell us about some of the other resources that are available to folks.
Sure. On the Supreme Court website, which is supremecourt.ne for Nebraska.gov, there's a section just for guardianship and conservatorship. We've worked really hard to have a lot of information on there. The packets that Judge Bezos mentioned are all on that website. There's 5 packets, packet A, B, C, D, and E, and therefore different types of guardian conservatorships. So those packets are there. There's a list of forms, so if you are a guardian and conservator, you can find extra copies of the forms on the website. We are having, as part of this special grant with the Unit on Aging, we're having our guardian conservator forms translated into Spanish. We have a lot of families in which Spanish forms are needed, and so we'll have those up this summer. And also this summer, we're having a guardian handbook. It's in a question and answer format. We've put all of the questions that we think we've heard people ask about: what is my duty, how do I do this, where do I find? And there's actual hot links within that handbook to take people to the right forms and the right answers. And then finally, for people who still have questions for the court system, either first you can go to your local county court and talk to the staff there, or there's an email address on our website that is NSC for Nebraska Supreme Court .guardianconservator@nebraska.gov. And people can email that address, and we have guardian specialists that can respond to them.
Let's talk more about local public libraries, because a lot of these things are also available at public libraries across the state.
Right. Yes. And actually I talked to Lincoln Public Library staff this morning. The Supreme Court partnered with the Nebraska Library Commission a few years ago to do outreach across the state at community public libraries, and the librarians there are ready to help anyone who wants to come in. And if you have a question about guardian conservator and your forms and how to get on the website, the librarians there can help individuals at the computer. They can help you pull up the forms. Of course, they can't give you legal advice, but they're working with us so they know how to help with information.
They can help point in the right direction.
Absolutely.
Right. Mm-hmm. Legal Aid of Nebraska, that's also available to folks.
Absolutely. And so Legal Aid of Nebraska has an elder access line. It's an 800 number, and Margaret Schaefer, who's also on this panel today, has information more about that. Anyone who's age 60 or older, doesn't matter how much income you get, can call that elder access line. And also the area agencies on aging, which are across the state, can also be a wonderful resource and can help point people to some legal supports.
Well, we have about a minute left. So tell us the website again, or the easiest way for people to find these resources. If they're just looking for more information, where's the best place for them to start?
I think the website is one place, the supremecourt.ne.gov, under Guardianship Conservatorship.
Well, unfortunately we're out of time.
Oh, okay.
But lots of good information here today. Thank you both for being here. If you want more information, you can always visit the Supreme Court website or call the numbers that will appear on your screen now. We hope you found the information shared by our speakers to be useful, and you'll take steps to prepare advance directive documents, protect yourself from consumer fraud and scams, and seek help with guardianship and conservatorship if the need arises. Please contact the Area Agency on Aging nearest you for further information on how to get legal assistance. The State Unit on Aging operates the Legal Assistance and Elder Rights Program in conjunction with other programs and services in the Aging Network to maximize the independence, autonomy, and well-being of older Nebraskans.